This is the story of Z publication against JAIZ.
Muslims should not be punished without a clear personal involvement.
Is responsible for enforcing state Sharia law.
In 2012, a Malay translated book became the center of national attention, not because it became a bestseller, but because it sparked a conflict between freedom of speech and the authority of religious enforcement bodies. This is the story of Z publication against JAIZ, a case that eventually became a landmark in Malaysian law. Z Publication Sdn Bhd is a publishing company registered under the Companies Act 1965. Its director and main shareholder is Muhammad Ezra Muhammad Zaid, a Muslim. The company published various intellectual works, including books that discuss religion and freedom. In 2011, the book Allah, Liberty and Love by Irshad Manji was published in Canada and entered the Malaysian market in June 2011. A year later, in May 2012, Z Publication published the Malay translation titled Allah, Kebebasan dan Cinta. The end began disturbing its opening. However, the book's content raised concerns among Selangor's religious authorities. The Selangor Mufti Department assesses the book and concludes that it was not academic, overly dependent on Western Orientalist views, and allegedly contradicted Islamic doctrine and Sharia. Based on this assessment, enforcement action was recommended. On May 28, 2012, a search warrant was issued. The next day, on May 29, 2012, the Selangor Islamic Religious Department JAIZ raised the office of Z Publication and seized 118 copies of the book. On the same day, Muhammad Ezra was arrested and taken to the JAIZ office in Shah Alam. He was later released on a bail bond to attend prosecution and the Selangor Sharia Court under Section 16 of the Selangor Sharia Criminal Enactment 1995 for publishing and possessing materials not constructive of the Sharia. On the same day, the Ministry of Home Affairs issued a banning order that prohibited the publication, sale, distribution, and possession of the book in both Malay and English version.
My intention in publishing this book was not to insult Islam, but to open intellectual and discussion. I believe Islam is strong enough to face different ideas and perspectives. When the book was seized and I was arrested, I realized this was no longer just about a book, but about freedom of speech and constitutional principles. I was charged as an individual even though the publisher was a company. A company does not have a religion, and this prosecution is unfair. I defend this case because basic freedom and legal justice cannot be sacrificed.
Z Publications and Muhammad Ezra filed for judicial review in the High Court, challenging JAIZ action and the Sharia prosecution. They argue that Section 16 violated Article 10 freedom of speech and Article 8 equality of the Federal Constitution, and that a company cannot be considered a Muslim person. Separately, a petition was filed in the Federal Court to challenge the constitutionality of Section 16. In 2015, the Federal Court ruled that the Selangor State Assembly had the legislative power to enact the provision, as it related to offences against Islamic teachings under the state list in the 9th schedule of the Federal Constitution. Despite the jurisdiction issue being settled, Z Publication continued the judicial review. The High Court dismissed their application. The Court of Appeal then ordered a full hearing in High Court. After a full trial, the High Court again dismissed the application, ruling that Section 16 was valid. JAIZ action were part of an investigation, and the search warrant could not be challenged to judicial review.
JAIZ was responsible for enforcing state Sharia laws when there was information that a publication might affect the Islamic faith of Muslims. The action was carried out pursuant to a valid search warrant as a part of an investigation under the Selangor Sharia Criminal Enactment and in accordance with established enforcement procedure.
Z Publications Sdn Bhd published and distributed a book entitled Allah Dibenci Anda, which was a translation of work by Shamanji. The book was subsequently banned by the Ministry of Home Affairs under the Printing Process and Publication Act 1984. Following the ban, JAIZ conducted a raid on the company's premise, seized the relevant books and arrested Muhammad Ezra for the purpose of prosecution in the Selangor Sharia Court under Section 16 of the Sharia Criminal Enactment Selangor 1995. Z Publications and Muhammad Ezra thereafter filed an application for judicial review to challenge the enforcement action and the legality of the provision. The High Court decision was appealed to the Court of Appeal. In 2020, the Court of Appeal ruled that the Section 16 was valid and constitutional but raised an important issue. A company cannot profess a religion and cannot be charged with Sharia criminal offences.
Basically, our point is simple. Section 16 of the Selangor Sharia Criminal Enactment only applies to Muslim individuals, not companies. So, Z Publication as a company cannot be prosecuted under Sharia law. The raid and seizures of the book were done properly following the legal procedure. But prosecuting the company director just because the company distributed the books was wrong and did not make sense. The Court of Appeal later confirmed that he is entitled to claim damages. What this case really shows is the principle of fairness. It's about knowing the difference between individual and corporate responsibility and making sure enforcement power don't override fundamental rights.
The Court of Appeal held that Section 16 of the Sharia Criminal Enactment Selangor 1995 was valid and constitutional as it was enacted within the legislative competence of the Selangor State Legislative Assembly. However, the court emphasized that Sharia criminal law applies only to individual Muslims and cannot be imposed on corporate entities. Accordingly, Z Publications would not commit a Sharia offence. The court further held that the prosecution of the company's director was an unlawful attempt to circumvent the inability to prosecute the company itself, and that such action was irrational and amounted to an abuse of prosecutorial power.
Islam values knowledge, but it also protects faith. Actions may be taken if something clearly contradicts Islamic teachings, but they must be fair and within the law. In Islam, responsibility is personal. A person should not be punished without a clear personal involvement. This case shows the need for balance between protecting our religion and ensuring justice.
For religious scholars, this case highlights the need to balance protecting religion and ensuring justice. The legal principle affirmed in this case is that Sharia criminal law applies exclusively to Muslims as individuals and cannot be extended to corporate entities unless expressly provided by law. Furthermore, personal criminal liability cannot be indirectly imposed on a directive solely on the basis of the act of the company. The case also underscores the importance of the rule of law requiring enforcement and prosecutorial powers to be exercised lawfully, reasonably, and without arbitrariness.
I believe the court's decision reflects the constitutional reality of Malaysia. It recognizes that Islam holds a unique and protected position and that state laws concerning Islamic matters fall within that scope. So, in my view, the decision is consistent with both constitutional principles and religious responsibility.
The case of Z Publication against JAIZ illustrates the position of Islam in Malaysia as a federal religion protected by the Constitution, particularly through the division of powers between the Federation and the states. This case shows that the states have the power to enact and enforce Sharia law for Muslims, in accordance with the 9th schedule to the Federal Constitution. At the same time, the Court of Appeal's decision stressed that such enforcement cannot override the principle of justice, including the distinction between the responsibilities of individual Muslims and corporate entities. This reflects Malaysia's approach to maintaining the special position of Islam within the constitutional legal framework.
The Z publication against Jaiz's case is not just about the book, it's about the limits of the religious enforcement, freedom of speech, and the boundaries of law and corporate entities. The decision left a deep impact of Malaysian legal landscape, a reminder that freedom and justice must go in hand.